Today I'll be talking about the history of AB 1087. AB 1087 is a vehicular manslaughter while intoxicated that was created by a Republican Assembly member, Joe Patterson, initiated February 20, 2025. Joe Patterson brings this bill up because he had an experience where a child lost his father to an intoxicated driver and realized that the person driving intoxicated had less time in probation than someone who was not intoxicated. This law prohibits someone from driving a car while under the influence of alcohol or drugs. This aligns with Penalty Code Section 191.6 because if they are caught, they get 3 to 5 years DUI probation, which may be changed if their sentence is more than 5 years, by adding a longer period of 5 years to probation if there is a vehicular homicide, and 1 year of misdemeanor, and 2 years for felonies. Once the bill was read and printed by the Assembly Public Safety, it was sent to the committee for a hearing to be analyzed on March 10, 2025. Then a month later, it had passed the committee vote, demonstrating the amount of support the bill was receiving for aligning the sentence for probation, which took place during April 24 through April 28 of 2025. Soon after, the floor action was taking place on May 23, 2025. The bill passed out of the Public Safety Committee with a sweep of a vote 14-0, expressing the strong agreement for AB 1087. Eventually was ordered for the next reading in the Assembly on May 27, 2025, where it would soon pass with a unanimous vote of 78-0. Once again, this vote is demonstrating a rare case of settling for these sentence adjustments. This bill was then received into Senate for referral and read for the first time, where it would be referred next to the Senate Rules Committee for an assessment on June 9, 2025. Soon after, it was officially assigned next to the Senate Public Safety Committee, where it would be reviewed to be passed 9 days after it was received into Senate, June 18, 2025. As of current status, AB 1087 is awaiting the Senate Public Safety Committee hearing as well as awaiting the vote. When or if passes, it will have to proceed next to the Senate Appropriations Committee, which will then move to the Senate floor. After moving to the Senate floor, it will need to final step in order to become the governor's signature. The goal of this bill is to reduce the incidents with vehicular accidents with drugs or intoxicated.
Hello everyone, my name is Carlos. I'm going to be talking about the implementation of AB 1087. This law is set to increase penalties for people who cause a death while driving under the influence, also known as DUI-related vehicular manslaughter. Now the question is, who is making sure that this bill works? This law or bill is going to be enforced by the Department of Justice, the local district attorneys, judges, and the prison system. Other states like Texas and Florida already have similar laws with strict prison time for DUI-related deaths as well. Now, who is affected? This law affects anyone who causes a death while driving drunk, but the impact hits certain age groups harder. For example, Black and Latino men are more likely to be stopped and charged with DUI offenses. Low-income people also suffer more because they can't always afford a strong legal defense like many other people. And most DUI fatalities involve men, about 80% nationwide. Now, while AB 1078 is tough on punishment, it doesn't include any actual more solutions to stop DUI crashes from happening. It doesn't fund alcohol education, addiction treatment, or technology like breathalyzer ignition locks. Without prevention, this law might not reduce these incidents in the long run. Although the sentences that are already set may somewhat deter them, it will not stop DUIs from happening. Now, in summary, AB 1078 shows that California is serious about holding people accountable for DUI deaths. But for real change, we need a law that also focuses on prevention and rehabilitation, not just prison time, for the people who cause these accidents and injuries.
Hello everyone. Today I'll be sharing a critical evaluation of California Assembly Bill 1087. This bill proposes longer probation for people convicted of vehicular manslaughter while intoxicated. Cool. So let's start with the potential benefits. First, public safety. So longer probation might help deter repeat DUI offenses by keeping offenders under supervision for a longer period. Second, we have recognition for the victims. Families often feel short probation terms don't reflect the seriousness of taking someone's life, so a longer term could show that the law takes these deaths seriously. And third, we also have rehabilitation opportunities. So probation can connect offenders to treatment and monitoring, which would help them avoid reoffending. Next, we'll go into key concerns. But there are important concerns with AB 1087, and one of them is definitely equity. So longer probation could disproportionately affect people of color and low-income individuals who often face more barriers meeting probation conditions like check-ins, fees, or treatment costs, according to Pew Charitable Trust 2020. Now we have the system capacity. California's probation departments are already strained, so longer terms could stretch resources thinner and make supervision less effective overall, and that's according to the California LAO 2021. So what really deters crime? So, this leads to a bigger question. Does longer probation actually deter crime? Now, research shows certainty of punishment, meaning the likelihood of getting caught, has a stronger deterrent effect than severity or sentence length, according to Pratt et al. 2006 and Nagin from 2013. Pratt and colleagues found that certainty deters crime more than simply increasing the punishment. Similarly, Nagin emphasizes people change behavior when they believe consequences are certain, not necessarily harsher. So longer probation alone might not reduce repeat DUI offenses unless it's paired with swift, certain enforcement. Right? So along with this, we also have our financial concerns, right? So there's also a financial angle. Longer probation means higher costs for probation officers, court resources, and treatment programs. So right now, AB 1087 does not allocate extra funding, raising concerns about whether counties can afford longer supervisions without sacrificing the quality, according to California LAO 2021. So now we have alternatives to longer probation, right? So instead of simply extending probation, there are alternatives that research suggests could be more effective, right? First, treatment-based probation. This approach ties supervision to completing substance use treatments, focusing on behavior change rather than just longer monitoring, right? So that's according to Pew Charitable Trust 2020. Second, we have specialized DUI courts. These courts combine therapy, close monitoring, and swift consequences for violations. So study shows that they can reduce repeat offenses significantly, according to the National Center for DWI Courts 2021. Third, we have graduated sanctions. So instead of longer terms, people get shorter probation, but face quick, certain consequences for violations. And that's according to Pew Charitable Trust 2020. And finally, we have restorative justice. This approach involves victims directly in shaping restitution, promoting accountability, and healing. Office of Justice Programs 2020. According to them, these alternatives could achieve AB 1087's goal without the drawbacks of longer probation terms. Now, the big policy questions. AB 1087 raises some big policy questions. So first, punishment versus rehabilitation. Should we focus on punishing people longer or helping them change through treatment and support? And then second, is AB 1087 driven by data or by tragic individual cases? Good law should be evidence-based and not purely emotional, and that's according to California LAO 2021. And then we have third, a mass supervision. Longer probation could keep more people under criminal justice control, even for technical violations. This contributes to what experts call mass supervision, like mass incarceration. And that's according to the Criminal Justice Center 2022. And these are all critical issues for California to consider. So, in conclusion, AB 1087 is well intentioned. It seeks to protect public safety and recognize the harm caused by DUI fatalities, but it raises significant concerns around equity, effectiveness, costs, and unintended consequences like mass supervision. Whether it achieves its goal depends on pairing longer probation with enough resources, treatment, and fair enforcement. Thank you.
Hi everyone, today I will present our final assessment and recommendations for Assembly Bill 1087, which addresses DUI-related vehicular manslaughter in California. This bill increases sentencing and limits probation, but my focus will be on whether this approach is truly effective and how it could be improved. I will walk through what the bill currently does, what it leaves out, why prevention matters, and suggest changes that can make it more impactful in the long term. Was AB 1087 the best solution? Assembly Bill 1087 was introduced to strengthen penalties for DUI-related vehicular manslaughter. It responds to a serious public concern by increasing sentencing and limiting probation for offenders. While this bill demonstrates a commitment to accountability, it focuses entirely on punishment. It does not include any preventative strategies, which limits its ability to reduce DUI incidents in the long term. What the bill leaves out. Although AB 1087 increases penalties, it leaves out key components that could help prevent repeat offenses. The bill does not require DUI education, substance abuse treatment, or any form of rehabilitation. It also lacks a system to track outcomes, which makes it harder to evaluate long-term effectiveness. Without addressing the root cause of impaired driving, the bill misses a critical opportunity to reduce future harm. Why prevention matters. In 2022, California reported 1,479 DUI-related deaths. Research shows that 1/3 of DUI arrests involve repeat offenders, and those individuals often have underlying risk factors that go untreated. One example of a prevention method is the ignition interlock device. This device has shown to reduce repeat offenses by about 70% while in use. Additionally, alcohol use disorder is a chronic brain condition, not simply a matter of poor choices. People can recover with access to evidence-based treatment like counseling, behavioral therapy, and dedication. Without including these types of interventions, the law misses an opportunity to prevent future harm. Making AB 1087 more effective. In order to make AB 1087 more effective, we recommend adding mandatory DUI education or substance use treatment to sentencing. This bill should also require the state to collect data on repeat offenses and evaluate how the law is being applied across different communities. Finally, we recommend including a 3-year review clause to assess whether the law is actually meeting its goals. These changes would make AB 1087 not only more effective, but also more focused on long-term prevention and public safety. In summary, while AB 1087 takes an important step towards accountability, adding treatment, education, and long-term evaluation would make it stronger and a more effective solution. Thank you.